Hi everyone, welcome to Lindalu IP course. I'm Tengfei and a chemistry partner and a former senior examiner from CNIBA. This time I would like to talk about the supplementary experimental data in China. In recent years, Chinese courts are accepting more and more supplementary experimental data. In the related provisions of Supreme People's Court in this regard, it stipulates that where an applicant for a pharma patent submits supplementary experimental data after the filing date and claims that the data proves that the patent application has inventiveness and sufficient disclosure, among other things, the People's Court shall examine the supplementary experimental data. A case is introduced below to explain how the court considers and determines to accept supplementary experimental data for pharma patents. The case has been concluded by the Supreme People's Court on October 26, 2020. The specification of the subject patent describes that the compound has a surprisingly high metabolic stability and bioavailability in the section of background, but the rest part of the specification does not mention such a technical effect, nor is the experimental data provided to verify this technical effect. In the invalidation procedure against the subject patent, the re-examination board did not accept the above technical effect described in the section of background due to lack of verification by experimental data. Counter-evidence 5 provided by the patentee was an experiment completed by the witness or by its own, and the experimental data was completed after the filing date of the subject patent. In addition, the witness was employed by the patentee and thus is a party of interest and could not provide further evidence for the experimental conditions and the specific information of the experimental data. Thus, the re-examination board did not accept the supplementary experimental data recorded in counter-evidence 5 and determined that the compound of the subject patent did not have the technical effect described in the section of background of the specification. The court of the first instance upheld the invalidation decision made by re-examination board. The Supreme People's Court gave the following explanation with regard to the supplementary experimental data recorded in counter-evidence 5. 1. Due to differential recognition of the prior art, it is inevitable that specific experimental data is not disclosed in the original application. 2. Generally, the applicant of the patent is required to prove that the patent application is ineligible to be granted by supplementing experimental data. Therefore, supplementary experimental data submitted by the applicant after the filing date need to be examined. 3. In the present case, the specification clearly describes the fact to be proven by the supplementary experimental data in the section of background. That is, the compound has surprisingly high metabolic stability and bioavailability. Credit should be given to the technical effect verified by the supplementary experimental data. 4. The employment between the provider of the supplementary experimental data in counter-evidence 5 and the patentee conforms the natural law and the practice of R&D, and thus should not be considered as the absolute ground for excluding the supplementary experimental data. For the above reasons, the Supreme People's Court decided to accept the supplementary experimental data provided by the patentee. Takeaways. 1. In China, a premise for supplementary experimental data being accepted is that the verified effect can be determined from the disclosure of the original application. Therefore, the effect proven by the supplementary experimental data should at least be recorded in the original application. When drafting the application, if the experimental data cannot be provided, it would be the best to at least describe the corresponding effect of the invention, thereby providing the grounds for supplementing experimental data that verifies the effect. In addition, the effect of the invention is best described in the summary of the invention or the embodiments, and should avoid being described in the section of background. 2. For the applicant of Pharma patent, it is advisable to record as much related experimental data as possible in the original application to lower the risk of supplementary experimental data provided subsequently being rejected. That's all for today's topic, and thank you for listening. I hope this could be helpful when the supplementary experimental data is needed to be supplied. If you have any questions, please always feel free to contact us. See you next time.